I'd like to follow up and discuss that very important case that the appeals court decided recently. It's called Fyffe versus the MBTA, and I've already done 2 video blogs about that case and some of the lessons we can learn for understanding what happens in personal injury cases and in personal injury trials. Please bear in mind that obviously the majority of cases do settle and are not tried. However, the way a trial would run in the anticipated evidence governs to a very large extent the nature of the settlement. So when I speak of trials, even though your particular case may not be tried, it is nevertheless strongly influenced in its outcome by what could happen at trial. So let's turn to this Fyffe case, Fyffe versus MBTA, and consider some of the lessons it has for personal injury practitioners and those who are suing personal injury plaintiffs. One thing that you have to bear in mind is that in the course of a case, a lawyer can only present evidence and question witnesses if there is a good faith basis to believe what is being questioned about. And the court specifically mentions that, and they found an absence of good faith for some of those statements and questions. Secondly, judges will often remind litigators, the attorneys for each side, that they must confine themselves to what they have reason to expect the evidence will show. So wild statements by either side are not permitted. And that is a lesson that needs to be understood. Certainly when I represent a client, I want that client to understand that there are certain rules governing the conduct of attorneys, and that they will be safeguarded by the system and by a zealous advocate on their side. The term zealous advocate also came up in this Fyffe decision, because the court said a lawyer must weigh his or her duty between being a zealous advocate as compared with somebody who is to be involved in the process of obtaining truth. And there is an ethical requirement to balance those items. I certainly come down on the side of zealous advocacy, but I certainly do not knowingly run afoul of any ethical rules. The court went on to discuss the loss of earning capacity argument made by the plaintiff. And this is something that I will discuss for a minute. A plaintiff who is unable to continue to work because of the injury suffered in the accident, the lawyer needs to establish what that person's baseline of income was. How is it easiest to do that? Through tax returns in the couple of years before the injury was sustained. From that, we get the baseline earnings, and with the appropriate medical testimony, we then know how the plaintiff will lose money in the future. There are some sophisticated, or perhaps not that sophisticated, calculations that go on to reducing the loss of earning capacity to present value, because there will be one award now contemplating the future, but the award is given in present time and therefore must be reduced to present value. There are footnotes and there are discussions in that case where that preferred method of presenting loss of earning capacity was not followed, and the court said that contributed to the fact that the jury award for the plaintiff in the amount of almost $1.2 million should be set aside. We'll look more at this decision for the lessons that we can draw in subsequent blogs. Thank you.